Hello, everyone. It's Friday. We made it. Thank you for joining us. Nick Chavez here with Marquen Valko, with Chavez and Valko, your key to immigration solutions. Marquen Valko, how are you doing, bud?
I'm doing well. It's Friday, like you said, and we have the form. We have some guidance. I guess that's what people are tuning in for, is the parole-in-place. So I'm doing pretty good. We waited for a couple of weeks. We thought it's going to be sooner, but it's today, and Monday is the day. So lots of work ahead of us.
Yeah. But before we begin, friends, we're closing in on reaching 5,000 subscribers on YouTube. So please help us reach that number by hitting subscribe. And as you know, by subscribing, you will be able to get the latest news about this program and other immigration news. So don't forget to subscribe. We really appreciate it. And well, Martin, as you said, it finally dropped. After 2 months, this program, Parole-In-Place, was announced in June. We were hoping it would be sooner, but like I say, better than never. I suppose it's good that we have it now, even though it was like at the last minute. It felt rushed. That's kind of the sense of it. We were discussing this earlier. But we finally got some filing information from USCIS. They published filing guidance regarding this PIP process, Parole-In-Place. And they published the form. It's a new form. And the filing guide and form, they're available to see on the website, USCIS's website, uscis.gov, for reference. And we know now that the form is form I-131F. It's a new form. And let's see here. It's the I-131F, and the filing fee is $580, and there's no fee waiver, or there's no way to reduce that fee. It's just $580 is what they announced. And you cannot file it now. You have to wait until August 19th. So that's something to consider. If you're working on it this weekend, you just have to wait until August 19th. And that's a Monday. So what we would like to do is just kind of go over this guide and just point out the interesting tidbits of information, at least what we have for the time being. And also, it's important to know that USCIS, although they gave us this information, it's great that they gave us this filing guide. They're still supposedly working on additional information regarding the requirements. So that's kind of putting the cart before the horse. And again, that's why we have this sense that it's being rushed. But they said that there's some additional information that they will be posting soon through the Federal Register. So we're looking forward to that. But I guess from reading the updated information, what we have from USCIS, there are some takeaways that could be helpful. So we can get started with that. And of course, if you have any questions along the way, please send them our way, and we'll try to address those questions. We have saludos, Patricia Tuliano. How are you doing? She's from California. She's a longtime subscriber. We appreciate you watching us. Thank you for doing that. So let's just go ahead and start talking about some of the takeaways that we have from this form, this new form. And it's an online form. They said that you can't file it by paper. It has to be done online. Let me just add that information here. And a couple of takeaways here, Martin. I think that one of the things I see here is that there's a note here about we had a question before that if this is going to, if they give you parole, will you be able to use it as a travel document as well? Because it is essentially, parole is essentially an entry permit. But and they gave you the answer here on that first note. They said, no, if they grant you parole, and that's why it's called Parole-In-Place, because you're getting it here, not getting it outside. You only get to use it, they grant it, and you can't use it to travel. In other words, you have to apply for a special travel permit. And they mentioned something here about the advance parole document. They do give some information about eligibility. There's a couple of questions that we still have that remain unanswered. And we'll talk about those questions. A lot of questions have been raised by our clients regarding what's called the permanent bar. The permanent bar for those who have entered the United States multiple times, or it could be that they were deported and they have re-entered, and that makes them ineligible to apply for a green card, whether you're applying for your green card here through a process called adjustment of status, or you're doing it outside. The other tidbit that I have here is that you can't. That's his application. We know that stepchildren can also apply, but you can't group them. So it's going to be something where each applicant has to file their own application, which makes sense, right? You can't, if you have an applicant who's also wants to include a stepchild and meets the requirements, that stepchild applicant has to also apply and make file their own application. What I also thought was interesting here is regarding individuals who, let's just say that you were married to a U.S. citizen and your spouse is now deceased. And I thought that was it was a good thing that immigration went ahead and said you can still apply for parole in place if you were married to a U.S. citizen as of June 17th or prior to that date. So if you have, or if you were wondering whether or not you qualify, and if your spouse is deceased, we can definitely look at that, and you may be eligible to apply for parole in place, which I think is interesting. The other takeaway that I have here is regarding, we do get a lot of questions about deportation. We have clients who were deported in the past, and they are wondering if they are eligible to apply for parole in place. We have clients who are currently in removal proceedings. And so what we were telling our clients is that we have to wait until immigration gives us some information. But here they went ahead and clarified. I think they provided some insight here. We know that people who are currently in removal proceedings, that is deportation proceedings, they'll have this opportunity if they qualify to apply for parole in place. If you have a deportation order, they said here that you can still qualify for parole in place, but they also mentioned that there might be some additional steps that you might have to take. And that could be possibly filing a motion to reopen with the immigration court to see if immigration or the Department of Homeland Security and the judge, if they're willing to reopen the case and terminate, so you don't have any impediment to apply for a green card later. Any comments, Martin?
Well, I mean, this is a pretty sensitive area when you're speaking about somebody who's already been ordered removed as a final order of removal. This is where you should, or the people should consult an experienced attorney, not just an immigration attorney, but also a removal attorney who would be able to look at these options and really what are the steps and how to go about it. Because once the person has a parole, then they should be eligible for adjustment for a green card. But before you can do that, if there's a final order of removal, there has to be some specific steps that have to be taken, and also consider what's the likelihood of a motion to be granted by a judge, or whether the government would join the attorney, the parties, in a joint motion to reopen proceedings, so that they could either seek to adjust before the immigration judge, or have the proceedings terminated and go before USCIS. So these are very sensitive types of cases that really require careful attention and analysis. And when people have these types of fact patterns, these backgrounds, they should consult, and not just kind of go out and throw themselves out there, but have it carefully analyzed.
Yeah. There is still a remaining question, right, with respect to deportation orders. There are individuals who've been ordered deported, and they were actually physically deported. It's not like they were deported and they're still here. They were actually deported and they had re-entered the United States. And that triggers that permanent bar that we're always talking about. And wondering if individuals who are subject to the permanent bar because of a prior deportation order, if they are still going to qualify. And I'm still, reading this, I'm comfortable with individuals who say, hey, I got a deportation order, but I haven't left. We can try, as you mentioned, we can try to reopen that case. We can file what's called a motion to reopen or a joint motion to reopen with the court and see if they're willing to reopen the matter in light of this new program. And they could very well do so. But when we're talking about a person who had an order of deportation and left the country and then re-entered, triggering that permanent bar, there's still a question about that, in my opinion, in my view. I know that colleagues could, reasonable minds could differ, but the way I'm reading it is that I think we're good so far, but there hasn't been any sort of assurance. And maybe that's when they're talking about we still are working on clarifying some information, that you can expect through the Federal Register. Maybe that will be some of that information, and maybe that would be maybe they will clarify that because it's somewhat good to be true. But I hope that we can do that without jeopardizing our clients or without putting our clients at risk. Because number one, our number one interest is to protect our clients. We don't want to put them at risk of deportation unnecessarily. Of course, they're going to be well informed. They're going to be conscious of the risks that are associated. We explain it to them. But if this is something that the person may not qualify and they deny, then they're just exposing themselves. So we just definitely want to make sure, at least I want to make sure that a person who's subject to the permanent bar may still apply. And I guess I'm holding out for some additional information through the Federal Register. Martin, we're getting some questions here. This is a question from Julieta. Hello, Julieta. Thank you for watching. About birth certificates, do they have to be translated or just the applicant? So the birth certificates, and you'll see on the instructions, and this is pretty much normal. This is a standard requirement for all applications for immigration benefits. Really, it's if you are presenting a document that is a foreign document, you have to have it translated. Not only translated, but you have to have what's called a certificate of translation. So it's basically somebody who has the ability to translate the document. They have to certify that the wording is correct. So yes, foreign documents like birth certificates, they have to be translated. Passports, the foreign passports, they don't. It's pretty much it's well understood. It's that the information there is what it is. And so, but birth certificates, marriage certificates, they do need to be translated. Thank you, Julieta. Sergio Perez, he asks a question. This one's in Spanish, but we could also do it in English. And it's about common law marriage. Gracias, Sergio, por su pregunta. Common law marriage, you could. I mean, you could. It is possible. It is a relationship recognized in Texas, and the USCIS's position is if the relationship is recognized as a marriage under state law, then they're going to go ahead and respect that. Eso dependerá en el estado donde vive. Si el estado reconoce matrimonios de unión libre, entonces hay posibilidad de argumentar que su matrimonio es legítimo y por lo tanto puede calificar para el Parole-In-Place. Gracias, Sergio. Thank you, Sergio, for your question. We have a question here from Seagull Terra. Martin, what will happen to those who apply? And this is the concern that a lot of us have, right? They apply under this new process? And what if there's a shift in administration? We have the elections coming up in November. We know that this is a creation of the current administration that views immigration policies differently from the predecessor. Here, we know that Trump favors more of an anti-immigration, where the policies are pretty much anti-immigration. So what are your thoughts on this?
Well, I mean, it's a risk for submitting the application, because anything could happen, and there's a pretty good indication with for example with DACA after Biden took office, and even before that, certain states and individuals, but states that may be affected by this could challenge this, like they did challenge DACA, and you could have an injunction, you could have a court order that would stop this application process, this program, and that would be it. So it's kind of going to get frozen depending on what the outcome, what the order is saying. It certainly had happened with DACA applications after former President Trump had basically rescinded that executive order, and then also you had the states challenge the DACA rule, and those basically got stopped, frozen at the USCIS. So applications that were submitted are still there. The checks were cashed if they were at that process, at that stage, and it basically got frozen. And so USCIS would not adjudicate, would not process those until there will be additional steps taking and see what will happen in the subsequent litigation. Now, if you're denied parole, do you face deportation? So it doesn't say it, but it depends on why or what was the reason for denial. And so when you read the instructions carefully, it talks about that you may be referred to a different agency, and that may be ICE, Immigration Customs Enforcement. It really depends. Now, we have not seen that happening. Typically, again, depending on the fact pattern, where somebody's DACA got denied, whether it was for for whatever reason it may have been, but it certainly it could happen. So there's really no any kind of promises that if it gets denied, that you will not be referred somewhere else to a different agency.
Yeah, and on that note, they even said on that policy, on the filing guide, I mean, it includes that long-standing criteria where, look, if the offense is serious enough, we could refer you. So they always have that lingering. But in practice, if it's something that's minor, they don't really mess with it because of the resources, right? They're trying to prioritize right now and really concentrate on serious criminal offenders, as opposed to your abuelito or abuelita who, maybe have had a series of traffic tickets or something like that. All right, thank you, Siegel, for that question. Just moving forward on the fees, looking at the filing guide again. Another takeaway, is about the fees. We know it's $580. They're not going to provide a fee waiver here. But interesting, I don't think I've seen this, or maybe I've just kind of overlooked it. It's the refund policy here that they have, that USCIS does not refund fees regardless of any action we take on your application, petition, request, or how long USCIS takes to reach a decision. Okay, so yeah, if you file it, they're basically saying they're keeping your money, and this is something to really, kind of know, because we don't know how long the process will be. I think we have an idea based on our experiences with other similar programs. where USCIS, they were lacking in resources. And whenever there is a lack of resources, you can pretty much bet that it's going to take a while. We've seen processing times over a year, 2 years, and then we end up having to file a lawsuit in district court to try to compel immigration to act on it. So here, they're basically saying, look, you file it, don't expect your money back. So that's something to keep in mind. And of course, for those cases or those issues where like the permanent bar, or it's very important that you consult with a lawyer before you invest your money or you spend your money with USCIS, knowing that they're not going to refund your money back. So it's important that you realize that.
But it's funny that you bring it up, because even in consultations we see that question, and I haven't seen that before, and you pointed it out that they are now stating explicitly that, hey, if whatever may happen, if it's denied or if it's rejected, we're not sending your money back, because a lot of times people ask that, well, why would they process it, right? Why would they cash my check if I wasn't eligible? And we see it a lot where somebody uses a unaccredited or a person or an attorney, or somebody who's not an attorney, to help file any kind of application or petition, and they don't get the fact that it's not until an officer interviews them or actually looks at it where they make a decision whether something should be denied. That money is already gone. It's been cashed. USCIS used it, and people ask that, well, why are they using it? Why are they cashing it if I'm not eligible? So
yeah,
it's just the process.
Yeah, very good. We do have a question from Instagram, and unfortunately I can't put that on the screen. But Steph Lorena, thank you for watching. She asks, is common law still, if you are common law married, are you still eligible to apply for parole-in-place? And this was a question that was asked earlier. And the short answer is yes. But if your state, where you live and the relationship was formed, if your state recognizes common law marriage. So common law marriage, really, you don't need a marriage license. In Texas, you don't need a marriage license to be legally married. You just have to meet 3 requirements, and that is that you are cohabitating with your partner, that you have agreed that you are essentially married or that you will be married, and that you are, and I think this is the most important one, that you have represented to other people or parties that you are a married couple. This happens a lot when a person is filing their tax returns, and they put down there that they're filing jointly as a married couple, and so that's kind of a giveaway that you are married, and a valid representation. Also in church, if you're presenting each other, hey, this is my spouse, that also works. And in Texas, you can do it. So you have, if you live in a state other than Texas, I would recommend that you consult a lawyer and find out if you are common law married, if your state recognizes a common law marriage. If they don't, then you have to have a marriage license to qualify. The other thing is the evidence. So if you are living in a common law state, what do? Do you just present evidence to the immigration officer and argue that under the state law that you are common law married? Well, you could do that. That's kind of the long route. I think the quickest route, and again, speak with a lawyer before you do this to learn what the consequences might be. Maybe there's some ramifications on your tax status or whatever, but the quick way to do it is, at least in Texas, is you could ask for an informal marriage certificate. That's what it's called. You could go down to any courthouse, and so long as you meet the requirements, you're attesting that you meet those requirements on a certain date. And if that date is before June 17th, then of this year, then you would meet that requirement for parole in place. Thank you, Steph, for your question. Moving down this filing guide that Immigration published today, and of course, for those who are joining us just now, if we're talking about parole in place, so we're looking at the filing guidance that Immigration published today. And so if you kind of note that I'm tired, that's basically what we've been doing. Martin and I, we've been looking at that and addressing questions. We're looking at this process here. Now we know the process. So we know that you submit your form online. Okay, they're saying that you don't do it on paper, you do it online. So you have to create a USCIS account. Very simple to do. And as a lawyer, we also have attorney USCIS accounts, so I can pretty much file for my clients. But the thing that we're waiting for is to see, or is to test it out, basically, because in our experiences, filing online has been somewhat a clunky experience. It's a lot of errors, I guess, that we've seen, and some of them have been fixed by Immigration, but it's something that you're going to have to see for yourself. Sometimes it doesn't work as we would hope. But you do file it online, and once you file the application online, you will get scheduled for what's called a biometric appointment. This is where they'll send you a notice saying that they'll give you a date and location. It's a support center. It's really straightforward. You take your information, you take your biometric notice, and this is where they'll take photos and they'll take your fingerprints because they want to get your background information. Obviously, that's going to be important part of this process. During the process, this is actually the way they did it here is kind of out of order. I would put the second part, biometrics, here, but what could happen during along the way while your application is in process is they could request additional information. The good thing about online filing is that you could respond online and you could upload the documents that they're requesting, and those documents could vary. It could be about perhaps you missed, you forgot to send in a birth certificate, or they need more evidence regarding your continuous physical presence. And here they say, well, we're going to request an interview. Well, we may request, and I've seen this language before in DACA cases, and I don't think we've had an interview, Martin, right? I don't think we've seen an interview, maybe one or two, but the likelihood of them being interviewed for this is kind of low.
Typically, you have an interview or something like this if the biometrics are not reading. If they cannot take your prints, then they may just want to have you come in and provide a statement, provide a sworn affidavit that your record is clear or something like that. But going back to your kind of wanting to move these sections up and down, I mean, it seems like you said, this was just done in such a quick manner that even I'm just looking at, we may send you a request for evidence or a request for information, RFI. I have yet to see on a family-based processes, these types of cases, an RFI, an RFE, but RFI. So it's kind of mind-boggling how this was put together and how quickly it was released. And we're still waiting for information that's supposed to be out on Monday. I don't know what else could be put out there when it's going to be published in the Federal Register. And they're kind of doubling down on it will be available for filing on the 19th on Monday.
So this is why, in my 20 plus years of practice, I don't think I've seen a situation where they put forth a program like this, right? And then don't give you all the information, all the eligibility requirements. They instead tell you, hey, hold on, we're gonna green light it so you guys can file your applications, but we're still working on some of the eligibility requirements, or at least some of the clarifying points, and that's kind of unusual. And that, of course, makes it seem like it's rushed, and all points point that way, all signs point that way, that it was probably rushed. I've got a question here, and this is from Sigal Deda. She follows up with if immigration is not aware of your presence in the United States and considering the risk of this being rescinded, is it still a good idea to apply? Well, what do you think, Martin? It's just kind of, this was the question that was raised a lot during DACA, right? If
you are unable to prove your physical presence in the U.S., right? Is that what, I mean, am I understanding it correctly?
Well, it's like, you know, if this thing is not going to work out, if they're going to pull the plug on this, now immigration's going to be aware of her.
Okay. See, I'm reading it differently. I'm looking at it like, okay, if I'm unable to prove physical presence.
Right. So now they're going to have their information. Is it a good idea to even begin with it? And I think that, go ahead, Martin.
You know, and it's easy for us to say it, for us immigration attorneys, and just kind of push you like, yeah, go ahead and do this or not to do this. I mean, we've seen practitioners who were very careful and almost afraid of let's say applying for advanced parole for DACAs because they're afraid that what if it will be pulled from underneath them while they're traveling, right? So it was kind of overly cautious, but in terms of, you know, what will happen. So even with deferred action, it says we are deferring the removal of you from the United States. I mean, that was the definition of deferred action. So they're aware of where you are, and they're saying all these tough words that we may do this, and I think it's good to be, you know, counting on that something like this could happen. But has it happened? And we've practiced for, you know, a couple of decades each. We haven't seen that, you know, unless you're going out there and the person is being charged with some serious crimes and convicted of those. I don't think that you or that person should be worried about something like this, but it's certainly understandable.
Yeah, ultimately the decision is yours, right? If you feel uncomfortable in filing or sharing your information with the government, that is definitely your prerogative and your right to just decide not to do anything. But if you want, there is an inherent risk in everything we do. In every application that you file with immigration, there is an inherent risk that they have your information and they can use it later. Okay. But when we're talking about something like this, which is humanitarian based, we don't see that. We don't see the government using it against the person and, you know, rounding people up and deporting. That's not to say that they can't do it. It's just in practice, we haven't seen it. And I will say that there's a lot of time we meet with clients with different backgrounds, and we often meet clients that you know, we're looking at their information and we're saying, man, did you apply for DACA? You were here for, I don't know, 20, 30 years. And their answer is no. You know, you know, my mom told me not to because I was, you know, they're going to deport you, or I was scared. I didn't want to give them that information. And then later on, you know, with DACA, they blocked new applications, so you can't file new applications. And I'll talk to them later, and they say, yeah, you know what, I should have filed something because at least I could have had a work permit. So you kind of have to balance that.
But then think about the rhetoric on the other side. We are going to deport million people if we get into office, right? So you hear that blasting in the campaign period. Then I mean, it's natural that people are you know, concerned about what could happen.
Yeah. Thank you for your question. And I think this is we have a question here from Volka and Uran. And this is the question that we've been asked about a lot, and immigration somewhat clarified it. What happens if you have a null deportation? Well, the way the immigration framed it, the way they stated it on their filing guidance sheet, is that if you are currently in deportation proceedings, then you're eligible to apply for parole-in-place. They're not going to deny you just because you're in court proceedings. If you have a prior deportation order, okay, let's just say that you were in court and the judge the judge denied your application for relief. maybe asylum, and you did an appeal, or you appealed and you lost, but you never left. You're still here. In those cases, they're saying that you can still apply, at least from what we're reading it. Where I need more clarification is what happens to those individuals who were ordered deported and actually left the country. They were physically deported, in other words, or they left the country after they were ordered, and then they returned illegally, because by returning illegally, that triggers another set of rules. And individuals that come back to the United States illegally after they have been ordered deported during the time period that they're supposed to stay outside, they're subject to what's called reinstatement of deportation order, where immigration can simply re-execute the order without the right of seeing a judge, or the right to see a judge, or have your case heard. So in those cases, that's not to say that we can't, or that's impossible. I think maybe what we should do is study your case more in depth to see if there are any good theories to reopen the case, not just because parole-in-place. Let's find out if there's a good basis. And then I also want to see immigration clarify that information for those who had returned. Thank you, Volkan, if that makes sense. I know it's late in the day, and it's Martin and I, we've been reviewing this and talking to people all day, so that's why we look very tired. Thank you, Volkan. Blank, I like this comment, Blank. So you're 18, you've been married 18 years, but Blank has been sending us comments, and it's been fun reading them. 18 years, 3 kids, they won't question. Nope, they're not going to question your marriage. They won't. We have a question here from Yadira Davila. Thank you for presenting your question. Once everything is proved, when can they travel to see their family? And that was the first thing that popped out when I was reading the guidelines. That was actually the first note, that if they approve your parole-in-place, you can't use your parole to travel. Instead, they said that if you need to travel after you've been approved for parole-in-place, you have to apply for advanced parole, which is a different type of parole. Here, you can use it as a travel permit. But again, we don't have guidance. We don't have any further information about that process. But that's...
I would just add, so I think they're comparing it to when they're hearing DACAs are getting advanced parole. So as soon as they get this parole, they think they can travel. But so with Yadira, presuming that you are granted the parole-in-place, then you, presuming you're eligible to file for adjustment of status, you would file your adjustment of status, and then you should be able to file for an advanced parole for the travel permit. And so while your adjustment of status is pending, presuming that you are cleared to travel and you have the travel parole, the advanced parole, the travel permit based on the pending adjustment, then you should be able to travel abroad, but not with what Nick said with this parole-in-place.
Yeah. So let's talk about, well, we got another question here, and how to know if one DOI can apply for parole-in-place. So thank you for your question. This was actually one of the things we were looking at, and I was looking for clarification when they dropped the filing instructions here, and was trying to figure out, okay, so what does it mean? What does it mean to have a disqualifying criminal background? And from what they said is that here, this is a note, that disqualifying crime could be anything that would make you statutorily ineligible for a green card, that would be likely to disqualify you from getting a green card. Let's just put parole in place aside, and if you were applying for a green card directly, you're subject to what's called these rules. And they have a fancy word. It's grounds of inadmissibility. Basically, it's just a long list of disqualifications. You know, traditionally, our immigration laws, right? We had a list of, they called them back in the day, undesirables, and then the language changed, and it included people who were, you know, vagrants, drug dealers, theft, and all that, right? And all that list, you know, they changed through time, right? Because society changes and evolves, and those are called the grounds of inadmissibility. And what DUI is not a crime that's listed as under the grounds of admissibility. In other words, if my client was trying to apply for a green card, having a DUI conviction will not disqualify that person unless the DUI, unless it was some sort of aggravating element, like there was a child in the car, or it caused a serious bodily injury. And at that point, it wouldn't even be called DUI. It would be something else, aggravated assault maybe. But DUI in and of itself is not a disqualifying crime for purposes of applying for a green card. It is, for whatever reason, if you're trying to apply for DACA. But as far as parole-in-place, they said if it's something that would likely disqualify you if you were applying for a green card, then it looks like you would not be eligible for a parole-in-place. How about those crimes that are not statutorily, like DUI? What they said is for those crimes that are not likely to make you statutorily ineligible, they're going to just basically look at it, and the default here is look at it through they call it discretion, meaning that they'll look at what you did and view it case by case and see if this is something they should deny your application for. But they said again that they're working on additional information, and hopefully we'll get more information through the Federal Register. So just make sure to subscribe to get those updates. Anything you want to add up to that, Martin?
No, that's you covered it. Yeah.
We have a question here, Martin. What does order means for DACA kids? What does it mean for those who have DACA? What does it do?
What does it do for DACA kids? So again, so DACA kids are those that are protected with the deferred action, and so they have authorized stay, unless they are married to U.S. citizen, unless they meet these criteria for the parole-in-place, I don't think that's going to do anything for them, because they would not be eligible if they don't meet the requirements. Is that how you're reading it?
Well, I don't think that has any impact. And Alina, you could make, if you can send us more information on your question. But doesn't have any impact at all on those who have DACA. If you have DACA, you don't have to drop DACA to apply for parole-in-place. This is something that you could do at the same time. In fact, for those who have DACA, we always like to see if there's a possibility of applying for what's called advanced parole, a travel permit, right? Because the whole purpose of all this is to try to make it easier for somebody who's eligible for a green card to avoid having to go outside. Because to apply here, you generally have to show that you were admitted, that you were given, that you entered with a visa, for example, that you entered with permission. And a lot of people entered without inspection. And so they're trying to fix that part so that you can apply for your green card here. A lot of our DACA clients, let's just say they're not married to U.S. citizens, or maybe they are. We always try to see if we could meet that requirement by applying for that travel permit, because once they leave and return, that's their last entry, and they would have entered with permission, and therefore meet that requirement if there is a qualifying family member or sponsorship here to apply for a green card. We're getting questions about DUIs. Ben also asks about DUIs, and as I mentioned, they didn't specify DWIs as a disqualifying crime. Again, they're saying that if the criminal offense is something that would normally disqualify you if you were applying for a green card, in other words, if it's subject under the grounds of inadmissibility, then it could disqualify you. And so DWI is not listed under the grounds of inadmissibility, so I wouldn't really be worried there. Domestic violence, that's a little different. There's a lot of case law here in Texas where in our circuit court jurisdiction here, where it doesn't necessarily rise to the type of offense that could disqualify you for a green card. But it just depends. There are different ranges of domestic violence. There's your misdemeanor and your threats, and then it goes from there to your more serious intentional resulting in serious bodily injury, which do tend to be those types of crimes that could disqualify you. So it just depends. But thank you for your question. This is again something that we need to, if you have a criminal offense and you're not sure, don't file your application just yet. Just hold on and wait for immigration to provide clarifying information on that. That's what I would recommend. Thank you, Ben, for your question. All right, so let's see here. Alina did clarify here. Our kids entered legally, so eventually when they marry U.S. citizens, do they have a better chance to get a green card? Yeah. Martin, you want to handle that?
Yeah. So, and I recognize Elena's name. So yes, that's basically what the parole is doing for others that are married to U.S. citizens. It gives them as if they entered lawfully, as if they were inspected or paroled. So that's basically exactly what this is replacing. It's replacing the legal entry. And so if a person enters legally and is married to a U.S. citizen and the marriage is bona fide, then they are able to apply for the green card to adjust their status. Yes. Mm-hmm.
Yeah. Thank you, Elena, for your question. We have a question from Letty from YouTube, and she asks regarding documents for the PIP. For tax returns, do they need all pages or just the first 3 or 4 pages? This is there was an interesting note again in the filing guidance that they published. They basically said that well, number one, they didn't specify like specifically, what documents they're looking for or to the extent that you need to present it or how much. They didn't provide any of that. But they did say something that was interesting and that could have been helpful when we were preparing those DACA applications in the past, which basically says that when you're approving physical presence, and let's see if I can try to look for it here. When you're approving physical presence, they're not going to be really sticklers on asking you to provide a document that pretends, and I think the wording they use that's going to cover
every week, every
month. And they fall back on this thing, what they call totality, which means, look, if looking back at your documents, let's just say that you did supply some documents from that year, or maybe just the first 2-3 pages of your to present the whole document as opposed to just some of it, because it adds more credibility. So here, if you're thinking about tax returns and you're only submitting maybe a couple pages, to add more credibility to what you're presenting, you want to present the whole document, and so they can consider it, right? So they can use the totality of the evidence. The same thing goes with lease agreements. Sometimes our clients will just give us maybe the first 2 pages, and then and then they'll skip the other 15 pages. I ask them to provide the whole amount. But in terms of how much evidence do you have to prove per year, because it's 10 years going back, right? There's not a particular number. It could be that your tax returns will satisfy, just submitting a copy of your tax returns for that year will satisfy that requirement, physical presence. So what I tell my clients is it's try to collect as much as you can. And then when we look at it, we look at it and we'll look at sufficiency, and there might be things that we're not going to include. But I think that we start off with trying to cast a wide net, collect as much information as you can. And if you don't have a particular piece of evidence, or you don't think you have a lot of evidence for a particular year, don't worry about it. Just, gather it all together and then consult with a lawyer or a legal representative, and maybe they can chime in, and you can look at that. Or you could submit it as is, and you can just wait for immigration to tell you to submit more information if they feel like they need to. That's what they're going to do. That's another thing, right? Once you submit the application, I wouldn't worry about them denying it outright if you don't present all the information or all the evidence. If you're lacking in a couple of years, or if they think you're lacking some evidence to show physical presence, they're not going to deny it just like that. They're going to give you a chance. And as I showed you, part of the process is the request for evidence. So they could send you a request via email or by written notice asking you to supply more evidence, and they'll give you instructions how to do that before they deny it. So thank you for your question. Let's see here. Steph Lorena, she asks a follow-up question on, and again, you can't see it on Instagram, but going back to criminal history, she's wondering if the disqualifying criminal history, would that include also minor offenses with marijuana? This is the thing with drugs. After 1990, during I don't know if you guys were old enough to remember this, but I certainly, Martin and I, we're old geezers, right? So we remember this, that the war on drugs, right? The whole crazy war on drugs, and it resulted in these really strict laws concerning drugs, including immigration laws. So what that means, people who were convicted of marijuana, they're subject to being disqualified for applying for a green card. There is one exception, and that exception is if you were convicted of one time possessing a small amount of marijuana, less than 30 grams. So if you were convicted of that of a minor possession, then immigration will give you an opportunity to apply for a waiver, and if they grant it, then you could apply for your green card. So that's the only exception. There might be some exceptions as well that apply for juveniles, but beyond that, drugs are really strict, right, Martin? It's really, really tough thing to overcome sometimes. Yeah. But as far as parole in place, I would say let's wait until immigration, USCIS comes out with the clarifying information that we're waiting through the Federal Register. We hope that they address this. Very important. Thank you, Steph, for your question. So let's talk about, let's have another question here. Yvette, what will be happening with spouses of citizens with deportation or in absentia orders if they already tried to reopen that order and they lost the motion? That's a good question. If the person, an in absentia order is an order of deportation where a person doesn't show up to court, and the judge enters an order in their absence, so in absentia, Latin, for the person being absent, and so there are certain rules that apply when you're trying to reopen the case. In some situations, you can reopen it when you didn't receive notice, or there was some sort of defect in the process, and you could argue that you didn't get proper notice. There are some exceptions, important exceptions that we can look at. There is immigration, or I should say DHS, which is they're the trial attorneys. They represent the government when we're talking about deportation. There is a way to get in contact with them and see if it's possible if they can join in on a motion, so they can reopen the case, not because of some sort of defect or argument regarding notice, but just because something like this, like Parole-In-Place, maybe this offers a solution, right? We're not talking so much about the violations or the defects in the process. We're just saying a way to resolve the person's situation in a humanitarian way, in a reasonable way. And nothing prevents us from talking and reaching out to the other side and saying, hey, we have a client who's a very good person. They tried to reopen the case, but for whatever reason, it was denied. And they appear to be eligible for Parole-In-Place. And look, even immigration says that they could, the immigration says that they're giving us an opportunity. So we would like to see if we can try to reopen this case, so that way we can terminate the proceedings and have an opportunity. If the case is, if you do apply for Parole-In-Place and it's granted, and the person's eligible for a green card, there's not a wall anymore. So that would be something that I would get in contact with an immigration lawyer and see if and I'm sure you have, but I think if you wanted a second opinion, we would be happy to look at that. Thank you, Yvette, for your question. You guys could probably tell that we're really tired. Been a long day. We have a question here in Spanish. Ligia, she asks in Spanish, how much is the application? ¿Cuánto costaría la aplicación? La tarifa de presentar la solicitud de este programa es $580. It's $580. That is what it is. I will say, for the talking about the criminal side of it, there is a requirement here for those who have been convicted. And I think here, if you see this question, what is your most recent form? I mean, the purpose of applying for a Parole-In-Place is to help those who entered without inspection. Here is asking you if you, for evidence that you entered lawful. It's kind of a trick question, I think. If you want to qualify, this is what you answer. You don't.
That's the quick $580 that immigration would make.
That will collect.
If you uncheck
yeah.
it.
Yeah, they're here. They're asking questions about the spouse. So you do have to provide them Social Security, date of birth, if you were wondering what kind of information immigration will have. But getting down here to the questions, again, one of the questions they have here is, if you've ever been in exclusion, deportation, removal, rescission proceedings. Basically, if you ever been in immigration court or wherever ordered deported. This is it's a yes or no question. It's a yes or no question. For those who have been deported or in the process, I highly recommend you speak with an immigration lawyer to see how we can address that. It's very important. For those who have a criminal record, here they ask, have you ever been arrested, charged with, or convicted of a felony or misdemeanor, including incidents handled in juvenile court in the United States? And here they don't want you to, if you have minor traffic violations, you don't have to check off. If that's the only thing you have, you don't have to check off yes, unless they were related to alcohol or drugs. This is the question, have you ever been arrested or convicted of a crime in any country? So not only here, but if you were convicted outside. And they also make reference here to this link here. Supposedly they're going to ask for more. They're going to provide, again, more information that you can look at their frequently asked questions section on the website. But I did make a note that for those individuals if you do have a misdemeanor, they indicate here if it's something like a misdemeanor in Texas, a misdemeanor C is something that they cannot. There's no jail time at all, and immigration says here if you've been convicted of a misdemeanor or felony, a misdemeanor meaning that you could be punishable by with jail time up to a year, 5 days up to a year. So that would exclude your misdemeanor C's. So according to this, you wouldn't have to provide evidence of those misdemeanor C offenses. I guess that's how I'm reading it. But I don't know. Here, they're also asking if you have filed a waiver application. And this brings a good point, Martin. We have a lot of clients who are in the process of applying for a green card through this process known as consular processing. And it involves filing a waiver, right? Because that's what they need before they go outside to their interview. Now with this parole in place, this kind of changes the game, right? If they qualify for parole in place, would they be able to apply for? I mean, what do we do for those who are in the process of filing a waiver or waiting for a decision, and this parole in place option becomes available? How do you see that, Martin?
Well, we want to see how far in the process we are, because the second step, this provisional waiver, is really the most important step in the 3-step process. And, if we have an approved waiver and the next thing is just getting the immigrant visa application process at the National Visa Center, and we are not there yet, and this will become available on Monday, and it's not going to get challenged. Obviously, nobody wants to go. Nobody wants to leave if they don't have to. And so if this goes through, I wouldn't be surprised if people would want to do both, right? So if they're still kind of working on the immigrant visa process with the National Visa Center, or they're waiting for the interview to get scheduled, but at the same time they could keep waiting for this. And if it doesn't get challenged and they obtain the parole, then they would skip taking a trip, unless they want to take a trip to their home country for the final step for the immigrant visa application. But really, I mean, if this is available to those, right, those that are, have a either waiver approved or waiver pending, I think that's going to be a no-brainer. It really just will depend on the timing, right? Will this take another 10 months or 12 months? Because if you get the parole and you get it granted, then you are going to be applying for adjustment of status, which is going to take, now 4 to 12 months, let's just say, what we're seeing with the current processing. So the issue with going to the consulate is you got very zealous consular officers who will dig and dig and dig, and sometimes they find something that is not even there. Who knows? Just it's really difficult to be able to help them right away, because it's anytime there's a finding or negative finding by the consular officer, I mean, you're talking about months and potentially a year or two before anything gets resolved, and so it's a no-brainer, right? I mean, if you have this going and this is opening up on Monday, and presuming that it doesn't get challenged and stopped, I would be looking at doing both.
Yeah. We have a question here from Ligia, and this is in Spanish. ¿Cuándo se puede aplicar? ¿Cuánto tiempo durará el proceso? So when is the starting date for the application? It's Monday. Van a empezar a aceptar las solicitudes el lunes, el 19 de agosto es cuando pueden empezar solicitando el parole in place. ¿Y cuánto tiempo durará? How long will it take?
Yeah.
Eso dependerá. Ahorita queda por verse. No sabemos. We don't know exactly how long this is going to take. But if I were going to guess, it's probably going to take. I don't think it's going to be quick. I mean, I could be wrong, and I hope I'm wrong, but I don't know. This thing was rushed, it seemed. The filing guidance we didn't get until the last minute, right? And they're still working on information. for us. And so
I don't know who said that, but I think somebody I've heard somebody saying that they don't even know who or where it's going to be processed. Obviously, it's going to be online, so they'll be distributing it. But I heard that they don't even have officers for it, and judging by the last few months and couple of years, what has been happening, there is just a shortage, of officers, and the resources are not there. So we've seen that with DACAs and other applications. So things weren't looking good, but then all of a sudden there was this uptick and this processing of especially after April 1st when they raised the fees, filing fees. We've been seeing some adjustments with marriage-based adjustments that were processed in recently. I got one in 41 days.
Yeah, I saw that. Awesome.
41 days, which is insane. Wow. And so I think that was it was a child parent one, but even green cards marriage based 60 days, 90 days.
That's awesome.
But then you have some DACAs that are pending 7-8 months, which is, and then you look at another DACA that is processed in 5 business days.
Yeah. This is a good question. So Anthony Quintuna asks, who will create the USCIS account, right? Because this application needs to be filed online. And do we use the citizens because the citizen here had previously used one for naturalization, or the applicant? Just reading the filing guidance, it should be the applicant. You are the individual who is applying for this benefit, and in fact, they kind of do specify that. So it would be you that would be opening up the USCIS account. It's fairly straightforward, and there's nothing to it. And as you probably saw as we were scrolling, they do ask information about your spouse. So they ask the questions are more tailored to you, directed at you as the applicant. And then there's a section there where it talks about your spouse, and this is where you provide your spouse's information. Thank you, Anthony. All right, so we have a question here from Marta Rodriguez. Thank you for your questions. I have a court rejected case for a DUI document. Do I add that? And also, how many documents to provide for each year? That's that question we just answered. But Martin, what do you think?
I think the question, if I remember, I don't have it in front of me, and my brain is fried. But I believe, it's any. I don't think does it talk about convictions or arrests as well? Because generally speaking, for any application benefit, immigration benefits, they want to see.
Yes.
Have you ever been arrested? They want to see if because you could dispose of a case with a really good attorney or with a really good plea deal, but they want to marry the discretion. They want to make sure that your case merits discretion. They want to exercise the discretion. So typically you include all, but you follow the directions. And with cases where you have some criminal issues, I would recommend consulting with an immigration attorney.
Yeah.
And how many documents? Again, when we're building the DACA cases, we're trying to hit every month, and then they do something like this, and they said, don't give us every month,
right?
Every day, week, or month. So maybe every 2 to 3 to 4 months. Maybe it will be 4, 5, 6 pieces of evidence for the year. It depends on the gravity of the evidence and how strong it is. And so it's a decision. It's kind of a game time decision when you see all the evidence in front of you. And you kind of make the judgment: is that enough? Is it enough to cover that, to prove physical presence, or will there be questions? And if you don't have it, then there likely will be questions. But if you do have it, then throw it in there. I mean, I don't think it matters.
Right. And then this is on page 15 of the filing guide here. They do say something about that. It says, you must submit sufficient documentation to establish your continuous physical presence for the entire time required, but you do not need to submit documentation for every day, week, or month. That's where they get a little snarky. Okay, we get that. So they fall back on this totality of the evidence. So if you're missing, maybe you have 1 or 2 pieces of evidence and you can't find anything else for a particular year, I wouldn't lose any sleep based on what they're the kind of standard they're applying here. They're looking at from totality of the evidence. It's somewhat of flexible. It's a broad standard where they'll look at it for what it is. And if the evidence shows that more likely than not that you were, and that's actually the standard to apply for an immigration benefit that's widely used, yeah. It's more likely than not. If the evidence, if you can prove more likely than not that you have lived here in the United States for 10 years, then that should be enough. So I'm kind of glad they kind of did that, because we didn't have that with DACA. And so with DACA, we were unsure, and we were having our clients get, for every month, if it's possible, because we were getting requests for evidence, if we were missing, like if there was a gap between 6 months, they wanted a little bit more information. So I don't think they're going to get to that point. And in light of their resources, I don't think they have the manpower to issue a bunch of art fees. As you can probably sense from the tone of my voice, we're tired, but we want to be here with you guys and help you all out. Okay, well, Delia, sí, en español vamos a cambiar. Básicamente estuvimos hablando. We'll do English and Spanish here. Sometimes when it's late, the Spanglish comes, the Spanglish monster surfaces, and so I'll confuse the words. But Delia Mendoza, she wants to know about this thing again, permanent bar. Queremos saber qué va a pasar a las personas que están sujetas bajo la barra permanente. Y les estoy diciendo a mis clientes, en mi opinión, es mejor que nos esperamos hasta que publican más información por el registro federal para estar seguro. Esa es mi opinión. Ya sé que hay colegas que tienen diferentes opiniones, pero no expresaron, no nos dijeron específicamente qué personas que están sujetas bajo la barra permanente van a calificar o no. Entonces, hay duda. Y les recomiendo que nos esperamos hasta que nos clarifican. So yeah, it's the permanent bar, right, Martin? A lot of individuals are, and we consulted with a lot of people here who were subject to the permanent bar because they've entered the state for a long period of time, and then they left and they re-entered, and that triggered that permanent bar. And we're wondering, man, are they going to qualify? And the reason why that we're confused about it is because when this was announced, Immigration, USCIS, they had it on their little, on their page that says, like, you have to show that you're also eligible for a green card, that you're admissible for a green card. And that we took that as, you meet the basic criteria, you're married, you've been living for 10 years, but you also have to show that you are not subject to like these bars. And then all of a sudden, this came out and they don't even mention it. And so, yeah, we're kind of, I would say, let's wait until we get more information. But there might be situations where, if our clients recognize the risk, it really depends on our clients. As long as they're well informed of the risks, there are no refunds. They told you guys right there. So if you file this application and then later on immigration changes their mind, they say, you know what, we made a mistake. We do believe now that people who are subject to a permanent bar are not eligible. Then guess what? They're not going to refund you your money. So better safe than sorry.
I mean, on its face, the application does not mention it, and the application does not even require or tries to solicit that information, whether or not you had or what time, how much time you spent in the U.S. and did you leave or did you re-enter? It does not address it. And like you pointed it out, one of the eligibility requirements, one of the bullets had that be otherwise eligible for adjustment, and that's gone as well.
Mm-hmm.
And so instructions have this vague reference to it, not instructions, but just kind of intro on the page. But the form itself that a person is completing does not go to that, does not solicit that information.
Yeah. Gracias por tu pregunta, Delia. Vamos a tener un show posiblemente el lunes para darles información acerca de este tema y contestar sus preguntas. Así que suscríbete para recibir las noticias más recientes. Gracias. Vamos a ver aquí. See, I always like it gets mixed up, especially this late in the day. All right. Carmen Wilson has a question, and I think Alina, I skipped yours, but I think it was more of a comment.
Maybe
Carmen,
Alina is asking in Slovak, so then we can do English, Slovak, and
there you go. We get to, so Carmen Wilson here asks, she's a DACA recipient and also an approved I-130. So yeah, can I send these documents for proof of my presence in the U.S.?
That's smart, Carmen. That's, you know, I would do that, and I would also probably throw in some other utility bills and taxes and things of that nature. But that's a good start where you have approved DACA receipts.
Yeah. So yeah, to answer your question, yes, DACA. If you still have your information, absolutely anything, your approval, your marriage, that with the approval I-130, you must have your marriage license, and as a DACA recipient, you probably have evidence that you lived here for quite some time, so you can definitely repurpose this. All right, so we have a question in Spanish, but I'll say it real quick. We are going to have a Spanish show, I promise. It'll be Miriam Garza, Lee, and I we do these all the time. Hola, Juan. Esa es la cosa que estamos discutiendo. Si una persona que tiene una deportación, es posible que la persona podría calificar para el PIP. Hay unos detalles que tenemos que ver más a fondo. Pero por lo general, inmigración dijeron que si la persona si la persona está en proceso de deportación o si ha tenido una orden de deportación previa, tal vez la persona podría calificar para el PIP. La cuestión aquí que tenemos qué pasaría a las personas que tenían deportaciones y salieron y volvieron a entrar, activando el castigo, la barra permanente. Si aquellas personas van a calificar, queda por verse. Esas son cosas que estamos monitoreando. And again, we have a show. Tenemos un show el lunes o la semana que venga en español para discutir este caso este tema más a fondo. Gracias. All right. Does we have a question here from Dozy? Does the stepchild in their 30s qualify? No. Well. No. So there is a provision there, and that's a good question. I mean, there is a provision to apply for parole-in-place if you are the stepchild of a U.S. citizen, but you have to meet the requirements at the time of as of June 17th, were you the stepchild, and to get to that, we have to get more information. In immigration law, a stepchild could be treated as a child if they meet certain requirements. And those requirements, you have to show that the relationship was formed. So the step parent or your biological parent was married to the step parent prior to you turning 18. And as soon as those requirements are met, then you could qualify as or you can meet that definition of a child. But now over 21, what is your take on this, Martin? I mean, it seems like they have to be children, and children in general have to be under 21.
That's the way I read it. So the step-parent relationship established before the child or stepchild turned 18, and they have to be a stepchild on that date. The stepchild has to have a physical presence on June 17, 2024, but you have to be a stepchild on that day. And under the INA definition, it would be to be under the age of 21.
Yeah. Okay, very good. Thank you for your question. Marta follows up. She filed the I-130 last year, and it hasn't been approved. Yeah, we apply for PIP. No, you don't need an approval for. It's not part of the requirements that you have your petition approved. So what I see people doing is applying for PIP first. If they are approved, then they could apply for their green card along with the I-130 petition. In your case, if your PIP is approved, and let's just assume your I-130 petition is still pending, I wouldn't worry. What you could do is you could apply, you could file your I-45 application, and on the application, you can connect it with your I-130. You can say that you can provide a copy of your receipt notice, and they will ask you for your receipt number, and you can provide that, and they'll connect it with the pending I-130 and process it. But we have people who are at that stage of the I-130. We have people who haven't filed anything yet. We have people who are at the provisional waiver stage. So, but that's not a requirement, in short. And thank you, Marta, for your question. Immigrants with a deportation, and this is again, and thank you. These are people that are probably joining us later. Thank you guys for watching us. That is something. With respect to, I can't even speak, Mark. With people with deportation orders, immigration somewhat clarified it for us. If you are in deportation proceedings, you could apply for PIP. If you have a prior deportation order, you could apply for PIP. The question we have is that if you have a prior deportation order and you were deported and you have returned illegally, thus triggering that permanent bar, would you be eligible? Immigration did not specify in their filing guide, and they left that open, but they also said that they're working on some, I guess, clarification, some additional information regarding the eligibility of the applicants. And so we hope that they will clarify this. I know that we have colleagues that maybe have a different take, but I kind of just wanted to see what happens here, not rushing it yet, because again, right, there's no refunds. So what if you file something right away and then immigration changes their mind and say, oh, sorry, guys, the permanent bar applies. And seeing how rushed this thing was, I don't think I trust immigration that it really discussed this issue, which is unfortunate.
When you talk about DACA, it's the same thing happened with DACAs. It's not like you just had one set of FAQs.
Yeah,
they would supplement them in this round and this round and this round, and that would basically change the requirements often. And so, not rushing and not being the first one to file, especially if there are these kind of underlying issues, a person should just really be careful and think it through.
Yeah. Thank you. Thank you for your question. Let's see. Urchit? Hold on. Urchit? Urchite.
It's okay. Like absolutely. Yeah,
absolutely. Okay.
We can probably start doing Slovak show, and I'm sure Alena will be able
ahoy,
to.
Ahoy. I know ahoy. Ahoy or something like that.
Ako sa mash. There you
go.
Ako sa
mash. Slovakia. That's great. All right. Let's see. We do. I didn't enter. So Joseph did clarify. So Joseph, his mother is now a U.S. citizen. Mother was married before I was 18. Yeah, but the way we're reading it, right, it seems like they're saying children, and the children, instead of saying son or daughter,
right?
Because children has a very specific meaning, and that means a person who's under 21, unmarried. Maybe this could be one of those things where they'll give us some clarifying information, Joseph. So just stay tuned. I mean, this is not the last time we're going to be doing this. We're going to be monitoring it. They're going to be publishing additional frequently asked questions and guidelines, and we'll be here to discuss that with y'all. So this is Samantha. Thank you for your question. Is in your professional opinion, do you see anything good about this? She realizes that this information is still fresh. And what do we think about this? I mean, I can share my opinion. In general, it's a good option for individuals who are are trying to get their green card, who maybe are in the process, maybe they're in the process of getting their waiver approved, or maybe they're waiting for their visa interview. And what this, if everything goes well with this program, and a person is able to apply for parole in place and is granted parole in place, that opens up some doors. And one of them is, instead of having to finish the process outside, they can finish the process, the green card process here. That is the whole point of this Keeping Families Together initiative of the administration. So in general, it looks good. In practice, we have, I mean, we have some practical concerns. I mean, we've seen immigration rush things in the past. Look what happened with the parole programs a couple of years ago with Ukraine and Afghanistan and Afghan nationals, and it was mishandled. It was chaotic. The parole programs that we see now for Central Americans, they're somewhat chaotic as well. And so we think, well, I think this was somewhat rushed. It was politically driven, I think, and there's a lot of signs that make me think that this is probably, there's going to be a lot of questions throughout this process, that maybe some modifications. But it is something that's on the table, and for some of my clients, if it's on the table, we have to discuss it, and in most cases, we take advantage of it. Thank you, Samantha, for your question. All right. I think we're pretty much, this is, we're at kind of the end here of this filing guideline. Again, we're going to go ahead and provide additional information, but you can see this on the website, uscis.gov. And basically, this is the application screenshot, the questions that you're expected to encounter. Mark, do you have any closing remarks?
No, I think the last question was that was asking if, in our professional opinion, do we think if it's any good? I think it's plenty of good, and it was a good kind of a closing question. If there's, as they say, 500,000 foreign nationals who are married to U.S. citizens who could benefit from it, plus stepchildren, I think it's always good where you could cut the waiting time, processing times in half, and don't have to go anywhere, and you can stay here. You could, if you have DACA, you're working in the U.S., you can continue working and provide for your family, and not having to separate from your family. Really, that's the whole point and premise. Keeping families together is the premise of the parole in place. So I hope it doesn't get challenged, or if it does challenge, it survives any kind of attacks, and it will go through, so that people could benefit from it, and become kind of whole members of the society, and obtain their green cards, and be able to then naturalize, for example. So we'll see. We'll there is always potential new information, as we've seen in other processes. So just stay tuned. We'll be here for you. We'll be here breaking it down, even though even when we're tired, like after this long week of waiting, what's coming down, and and when is it coming down? And so I think it was 12:15 or whatever it was when it just finally hit. So as we're doing other things throughout the day and consulting, we're kind of devouring it and trying to analyze it and see what's out there, so you could benefit from it, so we can answer your questions, so you don't have to kind of go out there and try your luck, but hopefully be able to use our analysis and our experience. But we really appreciate all of you. Go to YouTube, subscribe, because you're going to help us hit 5,000 subscribers milestone, and we are here for you. So we really appreciate your feedback and your questions.
Thank you, everyone. And if you have questions about this new program or about your immigration case, we're here as well. You can call us and schedule an in-person or a virtual consultation. Thank you, everyone, and take care of yourselves.